This is part 3 of Tort, continuing our discussion of trespass to chattel versus conversion factors when considering. Consider the duration and extent of the interference with the property. If it's greater interference, it's more likely conversion. The intent to assert an inconsistent right, the good faith exercised by the opposing party, expense or inconvenience, and extent of the harm. The greater the degree, the greater the likelihood a conversion has occurred. Trespass to land is a physical invasion of plaintiff's real property. You have intent and causation. In negligent and or reckless invasion, defendant is only liable if defendant causes harm to the land. Intent, you need only have intent to enter the land, no need to commit wrongful trespass, meaning the defendant need not know that the land belongs to another. Transferred intent applies. Looking at physical invasion, you do not need to actually physically enter the land. You may commit acts that affect the land, such as flood, throwing rocks, emitting particulates over the land. A failure to leave after a lawful right of entry is an invasion. So if you exceed your welcome, that can be considered an invasion. May be committed below, physical invasion may be committed below, on, or above the plaintiff's land. Appropriate plaintiffs are anyone in actual or constructive possession, owner, lessee, adverse possessor even. Distinguishing trespass to land from nuisance, trespass protects the plaintiff's interest in the land and requires physical invasion. Nuisance protects the plaintiff's use and or enjoyment of the land and does not require physical invasion. Damages for trespass to land, no proof of actual damage is required. Necessity as a defense. The defendant is privileged to enter on the land of another or interfere with another's personal property to prevent injury that is substantially more serious than the invasion or interference. The defense does not apply to intentional torts to property. A private necessity is a qualified privilege. The defendant is liable for actual damages, so if only you are in danger. A public necessity, which is where everybody's in danger, or you protect a large number of people. This is an absolute privilege, and the privilege applies even though the original entry is not necessary if the defendant reasonably believes that it was. Private nuisance, this is a thing and or activity that substantially and unreasonably interferes with use or enjoyment of land. Defendant's conduct must be intentional, negligent, reckless, or the result of abnormally dangerous conduct. Appropriate plaintiffs are anyone with possessory rights to real property. Looking at substantial interference, must be offensive, inconvenient, or annoying to a normal, reasonable person in the community. Unreasonable interference is unreasonable if injury caused by the defendant outweighs the usefulness of the defendant's actions. Again, unreasonable interference is where the unreasonableness of the interference is if the injury caused by the defendant outweighs the usefulness of the defendant's actions. Defenses to private nuisance are regulatory compliant. This is not a defense, but it may serve to show whether the defendant's actions were reasonable. Where you're coming to the nuisance, such as you move next to the defendant's factory, this is not a defense, but it may serve to limit damages. Remedy for private nuisance is depreciation of property value, personal injury, harm to personal property. Looking at injunctive relief, you have to weigh social utility of the defendant's conduct versus harm caused to plaintiff and others. And a public nuisance. Public nuisance is interference with right common to the general public, such as pollution. A private citizen bringing a public nuisance action must have suffered harm different from that suffered by members of the general public. Meaning, as an example, someone who can't fish a river because of pollution has not suffered a harm different than any other member of the public, but a fishing guide on that river may have suffered a harm different than others as a result of the decreased and or absent business. Remedy is damages. Moving on to negligence, and looking at the definition of negligence. This is conduct without wrongful intent that falls below the minimum degree of ordinary care imposed by law to protect others against unreasonable risk of harm. Elements of negligence are duty, breach, causation, damages. Now, negligence, looking at the duty specifically, you have to determine if there is a duty. If there is a duty, then that duty carries with it an associated standard of care. So you have to determine if there is a duty. If there is, what is the standard of care associated with it, such as the reasonably prudent person. Now, breach would be, did your conduct fall below that standard of care? Causation would be a connection between the act and injury, such as your failure to meet that standard of care caused the harm. And damages, you must show actual damages. A little more about duty. Negligence duty, again, you have a duty to meet the standard of care. This is to protect others or another against unreasonable risk of injury. This is owed to all foreseeable persons who may be injured by the defendant's failure to follow the standard of care. And duty to use reasonable care when the actor's conduct creates a risk of physical harm. Looking at the failure to act, generally you do not have a duty to act, even when failure to act would appear unreasonable. However, a duty does attach where the defendant voluntarily aids and or tries to rescue another. The defendant there might be liable for harm caused by their failure to act with reasonable care in performance of aid and or rescue. If the defendant places the plaintiff in peril, they have a duty to exercise reasonable care to prevent further harm by rendering care and or aid. Looking at the foreseeability of harm, if you are engaged in an activity that is dangerous and it's foreseeable that you could harm somebody through this activity if you do not use reasonable care, this creates a general duty to act with reasonable care. Again, you're engaged in an activity. It's foreseeable that if you do not use reasonable care in that activity, that somebody may be harmed. This is sufficient to create a general duty that you must then act with reasonable care. This is a majority view of Cardozo. This only applies to plaintiffs who are within the zone of foreseeable harm or zone of danger. Foreseeable plaintiffs, rescuers, or the plaintiffs coming to the aid of another. Unreasonable efforts to rescue are not a bar to recovery, but may be factored in reducing damages. Firefighters rule, emergency personnel or professionals are barred from recovery if injury results from risk inherent to the job. Intended beneficiaries, a defendant is liable to third-party beneficiaries, such as in a legal context, you're drafting a will, if legal business transaction is prepared negligently and the defendant could foresee harm. And that completes part 3 of torts.